Thank you for your questions. I will separate the discussion in terms of factual position and then constitutional legality, and in terms of the three questions that you brought to my attention. So, in light of the challenge that has befallen the country in terms of placing its legal context, I will argue the following. Number one, it's extremely important for us to know the enabling law. We all know where we are starting from. There was a brutal killing of 4 toddlers at Ggaba Early Childhood Development Center, and that happened in this month. And the suspect has actually already been arrested and actually committed to the High Court for murder charges. Now, obviously, the president, as we all know perhaps, has directed that the trial be conducted in Ggaba using a mobile court, what they call a community trial model. The judiciary has actually recently operationalized mobile court practice directions in light of 2026 under the Chief Justice. So mobile courts are defined as courts sitting outside traditional court premises for specific cases constituted by judicial officers under the judiciary framework. So legally, the institution exists in terms of policy and in terms of judicial directions, but its deployment in Ggaba is exceptional and politically visible. And that is something that we need to understand, even as we understand the constitutional challenge in light of the Ggaba debacle. In terms of constitutional legality and tenability, the core constitutional question would be, is a mobile court in Ggaba lawful under Ugandan constitutional architecture? And I will answer in the affirmative that yes, but with strict conditions. Listen, under the Constitution of Uganda, that is 1995, we have what they call judicial independence, and this is provided for by virtue of Article 128. Remember that. So courts are independent from executive directions. In other words, no person, including the president, may control judicial decision making. That is very, very important for us to comprehend. Therefore, it means the following things. The president may actually request or perhaps propose or even suggest, but cannot order a court to sit in a particular place or in a particular manner. That is extremely important for us to understand in terms of now this challenge that we have in as far as our country is concerned. It employs the following challenges. In terms of judicial authority to regulate these sittings, we have to understand that the judiciary, through the Chief Justice, controls that particular mandate, if you like, in terms of the court location, yes, in terms of procedure, and this is very important, but also particularly in terms of the deployment of judges. Remember that, and that is extremely important in terms of the discussion that we're having as far as the Ggaba issue is concerned. So we can know from the reports that these mobile courts were formed in terms of enabling by way of the judiciary through the judicial practice direction of 2026. So we are aware that they have that constitutional or legal mandate in that context. But that means that it makes these mobile courts legally possible. But, and this is very important, but the executive prompting must not become judicial compulsion. That is extremely important. The executive prompting must not become judicial compulsion. So it is extremely important for us to make that very clear, that we are saying that whereas it is good in the context of the judicial promulgation, but it has to be by virtue of judicial instigation. So there has to be the aspect of fair trial as provided for under Article 28. Any mobile court must still ensure that there is an impartial tribunal, there is presumption of innocence, and there is non-intimidation of the accused. That is extremely important. And also the aspect of controlled public access. You see, because then if we let everybody attend in the context of whoever wants to do whatever they want to do, then we are likely to have a challenge in terms of the dispensation of justice. So there is a challenge in terms of the Ggaba type of cases, because then we are probably having a debate in terms of what they call public trial versus emotional justice tension. Yeah, the Constitution allows public hearings, but not public pressure trials. And that is extremely important. So also not mob adjacent adjudication in terms of this as well. And also not symbolic punishment settings. So much as we are so much moved and desirous of having justice dispensed, we have to be careful of those amenities so that we don't find ourselves, rather than actually dispensing justice and actually rather than causing a bigger challenge in terms of the aspect of fair hearing. So the constitutional tenability in terms of this would mean legality has to be measured against sustainability. So even if lawful, the Ggaba model raises 3 constitutional stress points. Number 1, the risk of emotional adjudication. A crime involving children creates public rage, no doubt. I was equally affected in terms of emotional challenge, in terms of substantive torture, psychological torture, because this was overboard. And then the aspect of demand for immediate justice. I was one of those who desires the justice immediately. And then the aspect of the pressure of the judiciary. We're all looking at the judiciary. We're saying, what are you going to do in terms of this? So the danger in terms of that, the law shifts from reason-based justice to emotion-driven legitimacy. And that is another contextualization that we need to understand, even as we're making a case in terms of the substantive issues in terms of the Ggaba scenario. And then the aspect of judicial independence as a perception risk. Yes, even if judges are independent, perception matters. Yes, so if, for example, as it has been the case, if the president announces in terms of a community trial, yes, then we are saying, in light of the mobile court in Ggaba, then we are saying, wait a minute, this perhaps has taken the eye and the ear of the president. Then there are substantive challenges in terms of what is required of the judiciary, and the public are raised in terms of the perception. Yeah. So the outcome has to be very careful in terms, rather than it being predetermined or accelerated by executive will, it has to be operationalized within the mandates of the judiciary without any due influence, if you use that phrase loosely. Yes. And then the aspect of equality before the law, so that the law does not seem to be distorted in that context. So Ggaba is not a remote or perhaps so much inaccessible, but the fact that it is extraordinary in terms of justice delivery creates some kind of inequality, and therefore there are challenges that will the accused get normal court processes? Okay, we are saying, is it going to turn into a community spectacle trial? Those are challenges that we're asking ourselves. So the challenge in light, for example, of Article 21, in terms of the equality logic, has to be also construed indirectly in the context of what we're talking about in light of the Ggaba challenge. So to answer the debate in terms of the questions that you have put before me, I will be specific, I will be analytical, I will be constitutional in terms of giving you the best under which these courts are likely to proceed. You asked a question, what precedent does the Ggaba mobile court set? There are 3 possible precedents. Precedent number 1, there's an aspect of positive precedent. Why? We are saying it is likely to foster in terms of justice delivery, especially in terms of these serious cases. They are likely to be increased public confidence, because then we know that everyone's eye is open and analytical in this context. And then the aspect of decentralization of the high court functions, yes, so that we're saying we're now, justice being delivered to everybody in the context of rural areas, if you like. And then there's an aspect of structural precedent. Yeah, mobile courts may actually shift from exception as a normal tool, and therefore the judiciary becomes more flexible institutionally. And then another aspect in terms of the dangerous precedent that is likely to proceed out of this, when it comes to high profile crime, for example, yeah, we could argue in terms of special justice forums, yes, there is a risk of case by case exemptionism, yeah, and that it has to be understood in that context. Then the potential for the executive to influence over these judicial geographical areas also is likely to be also underscored. So the most important constitutional precedent is that justice becomes locational sensitive and emotional responsive, but not purely institutional neutral. And that is something you must understand in light of the debate that the country is probably undergoing tonight. So that is extremely, extremely important in terms of the dispensation of the Ggaba challenge that we have today. The other question perhaps was, is judicially playing to the gallery in terms of any implications? Short answer, I will argue and say it may not be playing into the gallery in intent, but it risks performing justice in a visible emotional theater. And that is something, again, you may want to think about in the context of the challenge that the nation is perhaps facing in light of this Ggaba scenario. And in terms of the broader implications of mixing law with emotion, we have to be very careful in terms of that. Erosion of judicial neutrality perception can also be perceived in this context. Even fair trials may actually be seen as perhaps symbolic justice, and that is something you have to be careful as well. And then the aspect of public appeasement trials. Yes, they could be underscored as public appeasement trials for purposes of creating some kind of sanitary pleasure for the people to absorb and understand that perhaps there is some semblance of justice, yet in the essence this may not be the case. And then the aspect of precedent of emotional exceptionalism. That is something, again, we have to understand in terms of the future cases that may demand. We are likely to have issues where we are also facing high profile, and they can argue and say, give us a mobile court justice sort of case, for purposes of dispensation of justice. So all these we should be thought about in terms of the contextualization of the Ggaba challenge that we're having in our country tonight. And then the aspect of the risk of the rule of law stability. Yes, we are saying that the rule of law requires predictability, and that is extremely important. And the rule of law also fundamentally requires uniformity, and also fundamentally the rule of law also requires procedural insulation from public pressure. Those are fundamentals, and we cannot rule away in terms of the dispensation of the Ggaba challenge that we're having tonight. So we should also be careful of emotion-driven localization that weakens that insulation, because then we are saying that if that is the case, then there are challenges that are likely to ensue out of this challenge that the nation is falling tonight. And then the question of, but also, do they counter the truth? That should be important in terms of a balance. We are saying that mobile courts, yes, can bring justice, closer to the victims. That is substantially true. It can also reduce backlog. That is also substantially true. It can also enhance legitimacy if properly controlled, and those are litmus tests that we have to explore in terms of the danger that befall if we don't do that. So the danger is not really in the tool, but it is how the emotional governed it can become. And that is something you must think about even as we're employing this challenge in terms of the Ggaba scenario. Then the question in light of how feasible is mobile courts in general. We are saying that yes, it is legally feasible, and that you cannot take that away in terms of that analysis, but you hope also to understand the feasibility is contextualized in the context that the judiciary has authority over these sittings. Yes, and that is fundamentally true. As I told you, we have a mandate, a constitutional mandate propounded by the Chief Justice in terms of the practice direction. The practice direction already does exist that gives you the modus operandi in terms of how this matter can be addressed and how it should be understood. But then the practicability becomes a question of conditional feasibility. Yeah, mobile courts work well, for example, when they are, yes, in these remote accessed areas, because that is fundamental, because then justice is now being dispensed to the local areas, but then the infrastructure may actually be weak. Yeah, and then the aspect of minor or mid-level offenses, how do we address those? And then the aspect of controlled security environment that may actually exist also as a serious concern, because people's emotions are charged. How we sure that the environment is sanitized in terms of the security? The weakness can also be serious in terms of serious criminal cases, for example, in terms of security risks, for example, in terms of crowd control challenges, for example, but also in terms of witness intimidation risks, yes, and talk about what the environment, controlling the environment in terms of forensic preservation, so that we know that we have substantive evidence in terms of when they are going to be called in court. And then the aspect of procedural complexity, yeah, we are saying murder trials, for example, may require forensic storage. We all know that, and extremely important. And then controlled exhibits. Do we have amenities substantive enough to control the exhibits? How about secure records? Do we have substantive amenities in these local areas to ensure secure records? Or are we just going to talk about being transferred from place A to place B? How about those process of transferring them? Are we saying that they're not going to be contaminated? How about the emotional contamination also? The community presence may actually influence the atmosphere in terms of the adjudication. All this have to be thought about in terms of the challenge that the Ggaba case may actually bring on table. And then the institutional strain, yeah? The judges, for example, the DPP's office, for example, the defense, for example, police in terms of logistics, all these have to be moved and have to be contextualized in terms of, and do we have substantive provisions in terms of the law, in terms of these entities to be able to furnish and execute their mandate as far as the judicial dispensation is concerned. So in terms of the final constitutional position, we are saying that mobile courts are constitutionally and administratively permissible. We're also saying yes, but they must be controlled by the judiciary and not the executive direction. That must be very true and that must be understood. Thank you, and thank you for your attention.